Corporate Books and Records. Section 74, Book to be kept Stocks Transfer Agent, in which shall be set forth in detail the time and place of the holding of the meeting. Every corporation shall keep and carefully preserve as its principal office a record of all business transactions and minutes of all meetings of the stockholders or members or the board of directors, trustees, including the stock and transfer of the book. How authorized the notice given, whether the meeting was a regular or a special. If special, its object, the present and absent, every act done or ordered at the meeting upon the demand of any director, trustee, stockholder, or member of the time when any director, trustee, stockholder, or member entered or left the meeting must be noticed in the minutes. And in a similar demand, the year and nays must be taken on any motion or proposition, and the record thereof carefully made the protest of any director or trustee. The records of all business transactions of the corporation and the minutes of any meeting shall be open to inspection by any director, trustee, stockholder, or member of the corporation at reasonable hours on business days, and he may demand writing for a copy of excerpt from said records or minutes at his expense. Liability of the officer or agent of the corporation for refusing any director, trustee, stockholder, or member of the corporation to examine and copy excerpt from its record or minutes. First, shall be liable to such director, trustee, stockholder, or member for the damages, and in addition shall be guilty of an offense which shall be punishable under the section 144 of this code. And second, that if such refusal is made pursuant to a resolution or order of the board of directors or trustees, the liability under this section for such action shall be imposed upon the directors or trustees who voted for such refusal. Defenses under the code in refusing the person demanding to examine and copy excerpt from the corporation's records and minutes. First is improperly used any information secured through any prior examination of the records or minutes of such corporations or of any other corporation. And second was not acting in good faith. Or third, not for a legitimate purpose in making his demand. Stock and transfers book, in which must be kept on a record of all the stocks in the names of the stockholders, alphabetically arranged in the installment paid or and unpaid on all stocks for which subscription has been made, and the date of payment of any installment, a statement of every alienation, sale or transfer of the stock made, the date thereof and by to whom made, and such other entries as the bylaws may prescribe. Right to financial statement. There are three right to financial statement. First is, within 10 days from receipt of a written request of any stockholder or member, the corporation shall furnish to him its most recent financial statement, which shall include a balance sheet as of the end of the last taxable year and a profit or loss statement for said taxable year, showing in reasonable detail its assets and liabilities and the result of its operation. Second, at the regular meeting of the stockholders or members, the board of directors or trustees shall present to such stockholders or members a financial report of the operations of the corporation for the preceding year, which shall include financial statement duly signed and certified by an independent certified public accountant. And third, however, if the paid capital of the corporation is less than 50,000, the financial statement may be certified under oath by the treasurer, any responsible officer of the corporation. Merger and consolidation. Two or more corporations may merge into a single corporation, which shall be one of the constituent corporation, or may consolidate into a new single corporation, which shall be consolidated corporation. The merger or consolidation shall have the following effects. First, the constituent corporation shall become a single corporation, which in case of merger shall be the surviving corporation designated in the plan of merger, and in case of consolidation be the consolidated corporation designated in the plan of consolidation. Second, the separate existence of the constituent corporation shall cease except of the surviving or the consolidated corporation. Third, the surviving or the consolidated corporation shall possess all the rights, privileges, immunities, and powers, and shall be subject to all the duties and liabilities of a corporation organized under this code. And fourth, the surviving or the consolidated corporation shall thereupon and thereafter possess all the rights, privileges, immunities, and franchises of each of the constituent corporation, and all the property, real or personal, and all receivable due on whatever account, including the subscription to shares and other choices in action, and all every other interest in or belongings to or due to each constituent corporation shall be then transferred to and vested in such surviving or consolidated corporation without further act or deed. And fifth, the surviving or consolidated corporation shall be responsible and liable for all the liabilities and obligations of each of the constituent corporation, in the same manner as if such surviving or consolidated corporation had itself incurred such liabilities or obligations, and in any pending claim, action, or proceeding brought by or against of any such constituent corporation may be prosecuted by or against the surviving or consolidated corporation, the rights of the creditors or liens upon the property of any of such constituent corporation shall not be impaired by such merger of consolidation under the section 80 of this code.
Appraisal rights refers to the right of a stockholder to demand payment of the fair value of his share after dissenting from a proposed corporate action involving a fundamental change in the corporation in the cases provided by law. So, appraisal right in any stockholder of a corporation shall have the right to dissent and demand payment of the fair value of his shares in the following instances. For number 1, in case in any amendment to the Articles of Incorporation. So, but remember, not just any amendment, or the amendment just consists or must have the effect of first changing or restricting the rights of any stockholder or class of shares. So, binago mo yung rights nila or nirespect mo yung rights ng mga stockholders na humahawak ng ganitong klase ng shares. Second, authorizing preferences in any respect superior to those of outstanding shares of any class. So, mayroong isang group ng shares or isang class ng shares na nagkaroon ng mga preferences over other shares. So, ikaw naman na nakahawak ka dun sa other shares na yan ay masabi mo nga, bakit ganon, parang hindi mo na siya gusto, so you can exercise an appraisal rights. Third, extending or shortening the term of corporate existence. So, if you are not agreeable to this, you can simply get out to the corporation. So, number 2, sale, lease, exchange, transfer, mortgage, pledge, or other disposition of all or substantially all of the corporate property and assets. So, napansin mo na binibenta na lahat, bakit ka pa magsistay sa corporation when they are no longer interested in keeping property for their operation? Third, merger or consolidation with another corporation. And fourth, investment of corporation funds in another corporation or business or for any other purpose. So they want to invest in another business. Kung hindi ka payag sa ganyan, maybe you do not have confidence in such a other business, so you can choose to exercise your appraisal rights. So, next is exercise of appraisal right, section 82. So first, any stockholder who shall have voted against the proposed corporation by written demand on the corporation within 30 days after the date on which the vote was taken for payment of the fair value of his shares. Failure to make the demand within such period shall be deemed in waiver of the appraisal rights. So, if the proposed corporate action is implemented or affected, the corporation shall pay to such stockholder upon surrender of the certificate or certificates of stockholder representing his shares. So, as of the date prior to the date with which the vote was taken, excluding any appreciation or depreciation in anticipation of such corporation action. Then, if within 60 days from the date the corporation action was approved by the stockholders, the withdrawing stockholder and the corporation cannot agree on the fair value of the shares. So, the fair value of the shares shall be determined and appraised by three disinterested persons, one of whom shall be named by the stockholder, another by the corporation, and third by the two. So, the findings of a majority of the appraisal shall be final and their awards shall be paid by the corporation within 30 days. So, after such awards is made, provided that no payment shall be made to any dissenting stockholder unless the corporation has unrestricted retained earnings in its books to cover such payment. And provided further, upon payment by the corporation of the agreed or awarded price, the stockholder shall forthwith transfer his shares to the corporation. Section 83. Effect of demand and termination of right. So, from the time of demand for payment of the fair value of stockholder shares until either the abandonment of the corporation action involved or the purchase of the said shares by the corporation, all rights accruing to such shares, including voting and dividend rights, so shall be suspended, except the right of the such stockholder to receive payment of the fair value thereof, provided that if the dissenting stockholder is not paid the value of his shares within 30 days after the award, his voting and dividend rights shall be immediately be restored. Section 84. When right to payment ceases. So, no demand for payment may be withdrawn unless the corporation concedes thereto. If, however, such demand for payment is withdrawn with the consent of the corporation, or if the proposed corporate action is abandoned or rescinded by the corporation or disapproved by the Securities and Exchange Commission where such approval is necessary, or if the Securities and Exchange Commission determines that such stockholder is not entitled to the appraisal right, then the right of said stockholder to be paid by the fair value of his shares shall cease. His status as a stockholder shall thereupon be restored. So, and all dividend distributions which would have accrued on his shares shall be paid to him. Section 85. Who bears the cost of appraisal? So, the costs and expenses of appraisal shall be borne by the corporation unless the fair value ascertained by the appraisers is approximately the same as the price which the corporation may have offered to pay the stockholder, in which case they shall be borne by the latter. So, in case of action to recover such fair value, all costs and expense shall be assessed against the corporation, unless the refusal of the stockholder to receive payment was unjustified. Non-stock corporations is one where no part of its income is distributable as dividends to its members, trustees, or officers, provided that any profit which a non-stock corporation may obtain as an incident to its operations shall, whenever necessary or proper, be used for the furtherance of the purpose or purposes for which the corporation was organized. So, subject to the provision of this code on the solution. Subject to the provision of this title, the provision governing stock corporation, when pertinent, shall be applicable to non-stock corporation except as may be covered by specific provision of this title. So, purpose of non-stock corporation may be formed as or organized for: first, charitable; second, religious; third, educational; fourth, professional; fifth, cultural; sixth, fraternal; 7, literary; 8, scientific; 9, social; 10, civic service; 11, similar purposes like trade, industry, agricultural, and like chambers or any combinations thereof. So, subject to the special provisions of this title governing particular classes of non-stock corporation. So, Section 89. Right to vote. So, the right of the members of any class or classes to vote may be limited, broadened, or denied to the extent specified in the Articles of Incorporation or the bylaws, unless so limited, broadened, or denied, each member, regardless of class, shall be entitled to one vote. Unless otherwise provided in the Articles of Incorporation or the bylaws, a member may vote by a provoke in accordance with the provision of this code. Voting by mail or other similar means by members of non-stock corporation may be authorized by the laws of non-stock corporations with the approval of and under such conditions which may be prescribed by the SEC. Section 19. Non-transferability of membership. So, membership is a non-stock corporation and all rights arising therefrom are personal and non-transferable unless the Articles of Incorporation or the bylaws otherwise provided. Section 92. Election and terms of trustees. So, unless otherwise provided in the Articles of Incorporation or the bylaws, the Board of Trustees of non-stock corporations, which may be more than 15 in number as may be fixed in their Articles of Incorporation or bylaws, shall, as soon as organized, so classify themselves that the term of office of 1/3 of their number shall expire every year, and subsequent election of trustees comprising 1/3 of the Board of Trustees shall be held annually, and trustees so elected shall have a term of 3 years. Trustees thereafter elected to fill vacancies occurring before the expiration of a particular term shall hold office only for the unexpired period.